Well, good morning to those of you out there. Welcome to our 8th webinar in our webinar health subrogation webinar series. Today we're going to be doing a little introduction and primer into Medicare Advantage issues. I appreciate everyone for accommodating my schedule earlier in the week. I know we were scheduled to do this on Tuesday and it's Thursday now. Had a really last minute emergency call to come and testify at a trial in Ohio, so I had to run out for that. I will tell you I had a great time. My first time testifying in court, kind of the opposite end. But it was fun. It was actually a good time, and went to a little courthouse in Ohio, and one of those that is so small that you walk in and there's not obviously there's not a scanner, there's no security, there's not even a sheriff there. It's just walk right in and you walk up a couple flights of stairs into this old courthouse, and here you are. So again, I appreciate everyone for accommodating our schedule on that one. So we obviously have gotten 8 presentations in and hadn't yet covered Medicare. And it may not be something that everyone does every day. Maybe it's a small piece of your book of business. But given the current demographics and how the Medicare Advantage program is increasing in membership and enrollment, it's something that will likely be on your radar soon, or it will continue to expand. So we thought it'd be best to just kind of dive in and start covering the basics. I'm going to go through a little bit of the background first for everyone, so we can kind of get a structure of what the Medicare program looks like, cover the Medicare Advantage part of Medicare, talk about the reimbursement rights that Medicare Advantage plans have, and then I'm going to turn it over to Nancy, who is going to kind of get a little bit more into compliance and best practices, just to try to make sure that we are all doing what we should be doing, because best practices are different handling Medicare than they are if we're handling, for example, an ERISA plan. And so we got to kind of talk about those differences and highlight those. She's also going to get really kind of into the weeds on the statutory recovery formula. So stay tuned for that. And then at the end, if there's any questions, again, we'll try to cover questions as we go through if you've got them. I will apologize that Catherine is not on this one, so I am going to be trying to man the controls myself. And so if there's any problems with the questions, just blame me. It's my fault. But without further ado, let's kind of just jump right in. So Medicare, the act itself is rather large. It's divided into 5 parts, and fortunately they're lettered. So it's Part A, Part B, Part C, Part D, and Part E. So that part at least is simple. Parts A and B are the original, I guess, the Medicare program that you're all familiar with, that people were enrolled in from the beginning. That provides, basic hospital and physician outpatient services. Now, Part C of the Act is the Medicare Advantage program. That's the program that is administered by private insurers, and essentially they are administering Part A and Part B benefits, but they're doing it through private insurers. Part D is the prescription drug plan, and most times that is just affixed onto your Part C plan if you're enrolled. Part E, super important. That is where all of the definitions, exclusions, and various reporting requirements are found. Courts have described the Medicare Act as one of the most confusing statutory schemes out there. And for someone who's had the opportunity to kind of delve into it, I completely agree and understand. I think you should think of it like as if it's an old farmhouse. And over time, Congress has put on additions, different wings to the house. Unfortunately, they haven't always used the same building materials. So although everything is connected, it's still a little bit confusing when you have to look at it over time and the different parts and sections that Congress has added onto it. So if you're confused when you start looking at the cases or trying to understand the different parts, you are not alone. So Medicare Part C, the Medicare Advantage program, is what we want to focus on because Parts A and B are limited to the governments, and they're handled by private contractors. They've got their rules, and typically that part is not going to be handled by private subrogation vendors or insurance companies. So I'm just going to focus. We're really going to focus here on Medicare Advantage because that is what the majority of the audience is going to be familiar with or potentially looking at handling in the future. So we're going to focus there. It was created in 1997. It was originally called the Medicare Plus Choice Program. Fortunately, at some point they rebranded that as Medicare Advantage. Sounds a lot better, at least for marketing wise. It's grown exponentially since it was created. Just if you look back to 2014, the penetration rate, which is effectively the enrollment rate, 31% back in 2014 of all Medicare enrollees were in Part C plans. And so what that effectively means is that 69% were enrolled in the traditional Part A and B. Flash forward to 2022, and it's 48%. So you've seen a huge spike just in the last 8 years. By 2032, CMS is projecting the penetration rate to be 61%. So that's going to be a majority of all Medicare beneficiaries are going to be enrolled in a Part C plan administered by a private insurer, and likely something that you're going to be seeing much more of if you're not seeing it already. One important thing that I want to highlight is that although the Part C plans are administered by private insurers, these are government dollars. They come directly from the Medicare Trust Fund. They are paid essentially in a capitation payment to the insurers to administer the lives that they have enrolled in their particular group. And there's a complex bidding process and formula that goes into exactly how the capitation payment is made. I don't want to get too far into the details of that, although we will touch on it a little bit later. The important thing to know is that even though it's administered by a private insurer like Humana or United or Aetna, these are funds that come out of the Medicare Trust Fund. So background. Let's back up. So we've talked about Part C a little bit more. Part E, super important. Part E is super important. That is where the Medicare Secondary Payer Act is found. Again, this was a rather important piece of legislation back in 1980. So that means it predates the Part C program. Although at the time there were these a random lot of Medicare risk plans that were private plans, just not a lot of them. So in 1980, Congress was already seeing financial pressures on the Medicare program. And at that time, if you were on Medicare, it was primary. It paid primary. So you didn't have to worry about, well, I've got this other insurance through my work, or I may be covered by, a different policy, or there was an auto policy that might, no, it didn't matter. Medicare was primary, Medicare paid first, and that was it. So in order to kind of stem the financial pressure, Congress passed the Medicare Secondary Payer Act that basically flipped that around and made Medicare secondary to any other insurance. So what they did was they put on a little addition here to Part E of their house, and it applies. Here's one of the key things in the Medicare Secondary Payer laws is that it applies to any payment under this title, and I've italicized that in the PowerPoint. Under this title refers to the entire Medicare Act, so that any payment, whether it's under Part A, Part B, or later Part C or Part D, any payment is subject to the Medicare Secondary Payer Act. Super important to understand that. So CMS is in charge of the Medicare program, and they provide direction to Part C plans. Unlike if you're sitting here and you're doing ERISA work and you're trying to understand what rights your plan has, you're looking solely at the plan language. That's not what we're doing here. First, we're turning to the statute, the Medicare Act that we talked about, but there are a number of other sources of rules and regulations that apply here because we are operating under a government agency. And so first and foremost, CMS is issuing directives through rules and regulations. And then there are also guidance that they have through informal guidance documents. One of the things that CMS has made clear to Medicare Advantage plans is that they absolutely must be recovering from third parties. They can do that through a traditional pay and chase model, but Medicare would prefer that Advantage plans also avoid paying any costs from the start by coordinating benefits, essentially directing providers to bill the third parties directly, whether that be an at-fault third party or a no-fault auto policy. The best practice is always to avoid paying conditional benefits from the start and having the primary plan pay them. And it's not an empty guidance at all. In fact, CMS expects Part C plans to be auditing themselves and identifying those benefits that could have been recovered or could have been avoided but were not. And then if in those situations where they're not actively subrogating or recovering from third parties, they actually cannot include those costs within their bidding process. So it potentially, if you're not doing a good job at avoidance and recovery, then you may take a big hit on what your capitation payment will be going forward. These recovery costs are also an important factor under the Medicare medical loss ratio under the Affordable Care Act. So you're required under that to account for your coordination of benefits of subrogation as a part of that revenue. So it's important across the board to make sure that we are avoiding costs and recovering those costs. Again, some more direction to plans. So in addition to the statute, you've got to be focused on knowing the regulations. Follow the regulations that the Secretary issues. Those regulations take the form initially of 42 CFR 422. That is applicable directly to Part C plans. I would focus your attention on 422.108, a very important regulation. It states that Medicare Part C plans basically have the same rights to recover as the Secretary does, and it also incorporates by reference all of the traditional CMS regulations in Chapter 411. Another source of guidance, super important for you to follow, is the Medicare Secondary Payer Manual. In particular, I'd focus you to Chapter 7, which governs the third-party recovery rules. If you're doing this work, you need to have that chapter, that manual by your side. And then there's also national coverage determinations published by CMS. These are maybe less important if your sole focus is on third-party recovery aspects, as there's not a ton of reports in there about that. But you should be familiar with them because on occasion they may come out with some additional guidance there. Again, here's some more guidance on the third-party recovery angle. The Medicare Advantage Organization will exercise the same rights to recover from a primary plan, entity, or individual that the Secretary exercises under the Medicare Secondary Payer Regulations. And so that is the important regulation that I was talking about that you should be familiar with. In addition, there's an important memorandum out there that talks about how Medicare Advantage plans have the same rights and responsibilities to collect for those services. Now, as a matter of history here, I'll kind of take you back to some of the litigation history that got us all off really on the wrong foot. So in the early 2000s, there wasn't, obviously the act had just come in 1997, and so the claims were working their way through. Plaintiffs' lawyers weren't quite used to this private option, and the state of mind, I think back then, was that Medicare Advantage is being paid by a Blue Cross Blue Shield, a private entity, so I'm going to treat them just like I would any other private insurer under state law. And so there was a lot of, I guess, a lot of initial contention, a lot of initial litigation over what rights these Medicare Advantage organizations had, and whether their liens were subject to any sort of anti-subrogation provisions under state law or not. And as I kind of told you earlier, this was a difficult statute to read. It was a difficult statute to understand because of the many haphazard additions that Congress had put on. And so initially, what lawyers for Medicare Advantage organizations did is they looked first at the addition. So at the section that Congress had put on the act, they looked in there and they found language that said that, the Part C plans had a right to charge primary plans. They had a right to bill primary plans. And so when they filed these initial lawsuits or defended against claims by the participants, the enrollees, they cited the Part C, or in this Angstrom case, you'll see they cited a particular subsections of Part E that created that particular Medicare risk plan. And the language they cited to was, this right to charge language. And courts looked at that language and said, yeah, that's great. That gives you potentially a right here, a federal right to recover back. However, what it doesn't open up for you are the federal courts, because nothing in Part C contained a private cause of action. Nothing created a federal vehicle to enforce your rights. And so all of these early cases really got, like I said, they got off on the wrong foot because they all ruled against the Medicare Advantage plans and their ability to exercise their rights in federal court. And so this was obviously to the joy of the plaintiff's bar, they felt that because there was no cause of action in federal court, that Medicare Advantage plans would be stuck in state court and subject to state laws. Well, fast forward a little bit to the early 2010s, and really what happened was Humana and their lawyers kind of dug a little bit deeper into Part E and found this private cause of action. So this is separate from the government's cause of action. It's a private cause of action. It's it's a little bit ambiguous. It just says there is an established private cause of action for damages, which shall be in the an amount double the amount otherwise provided in the case of a primary plan which fails to provide primary payment or appropriate reimbursement in accordance with paragraphs 1 and 2A. So this is found at 1395 YB3A. As you can see from it, it doesn't specify who is a plaintiff. There's no specific defendant. It's merely almost situational. Basically, if that primary plan has not made reimbursement, then there is this private cause of action. And so Humana jumped on this particular cause of action and first utilized it in this Avandia case that came out of the Eastern District of Pennsylvania and then up into the Third Circuit. So this argument essentially took away all of the prior case law involving whether MAOs had an implied right of action based on their right to charge or right to collect, and said, no, we don't need that because we have this actual express cause of action that Congress gave us. And the Avandia Court of Appeals decision here from the Third Circuit was an absolute game changer. For lack of a better term, it really allowed MAOs to now vindicate their rights in federal court, where they were otherwise had been subject to potentially being stuck in state court. Avandia was then later adopted. That rationale that MAOs have this ability to exercise the private cause of action was adopted by the 11th Circuit later in another case involving Humana against Western Heritage. And then after that, district courts from around the country have joined in as well. In fact, there's not a single federal court anywhere that has held that an MAO cannot access this private cause of action to enforce their rights. There is, and we'll talk about it in 1 second, one case that's pending that we'll talk about. But let's talk about what this private action actually means. As I said, there's no specified plaintiff and there's no specified defendant. So who's using it and how can they use it, I guess, are the questions. So first, Avandia and Western Heritage answered the question that Medicare Advantage plans can access this provision, but they're not the only ones. Obviously, enrollees can access it. So if it's a Medicare beneficiary and they haven't been paid by, for example, a no-fault carrier, they could potentially use that to sue the no-fault carrier. But they're not alone either. Providers can, medical providers. For example, let's say that the medical provider has been paid by the MAO. They're not particularly happy about that because Medicare rates are about 1/10 of what the actual charges are, and so they'd rather have, for example, a no-fault auto carrier pay those bills at 100%. And so they're able to access the same cause of action to go after, in this case, State Farm, to make State Farm pay their full bill charges. What are downstream entities? So if you're representing a downstream entity, you can also access this cause of action. Downstream entities are those independent physician associations or other entities that Medicare Advantage plans basically subcontract with to deliver Medicare benefits. It's kind of like an HMO type concept, is that the MAO will then issue basically a capitated payment to that organization to treat a subset of their enrollees, and in those cases, that downstream entity is on the risk. And if they're on the risk and they've incurred costs to treat one of these Medicare beneficiaries, then they have a right of action. And so basically, courts have said anyone connected with a Medicare Advantage plan in some way that has been injured by a primary plan's failure to pay has standing to bring a private cause of action. So then the second question is, well, okay, all right, great. We've got a claim here, but who are we bringing it against? Do we have to bring it against the enrollee, maybe like we would with an ERISA plan, where we have to sue our own participant who hasn't reimbursed us? Well, maybe. The courts are a little bit divided on who actually may be sued. The one category where they're not divided on is that absolutely primary payers are the proper defendants. So in other words, we're talking about the insurance companies who have potentially paid an at-fault settlement, insurance companies who issued no-fault policies, PIP policies. Whoever hasn't paid that was primary should have paid. You are a proper defendant, no question. So if we're handling a typical case and XYZ insurance company doesn't reimburse our Medicare Advantage plan out of the settlement, we can always go after the insurer that funded that settlement. That's very different than a concept you might be familiar with dealing with health insurance or ERISA work, where our primary focus is where the money is and where the participant is and whether we can still pursue them, rather than how do we go after the insurance company that didn't reimburse us out of the settlement. So enrollees, can we go after our own beneficiary where they've received the settlement but refuse to pay us? There is a specific rule, a regulation, 42 CFR 41124, subsection G, that says that we have the right to recover our payments from any entity, including a beneficiary, a provider, a supplier, a physician, attorney, state agency, or private insurer that has received primary payment. So that would presumably tell us that we can. However, there's one court that has disagreed with that proposition and said, that regulation is somewhat counter to the statute, and the statute doesn't clearly say that you can pursue your own enrollee. Rather, it says you can pursue primary payers. And so the case law out there is kind of divided as to whether you can go after your enrollee. There are cases that say that you can, but it's kind of unclear. And the same is true with attorneys. In ERISA, we're always going to be likely always going to be adding the attorney as a defendant if they have the money. Some cases have said you can do that under Medicare. You can go after the attorney. The Paris Blanc case that came out of Virginia there, and then there's a Schrader case that came out of Texas, said you could do that. But again, this Aetna versus Guerrero that's out of Connecticut said you can't do that. Medical providers. Here's another case, another interesting case. The question was whether you could go after a medical provider for example, a Medicare provider was paid twice, once by the MAO and once by the no-fault plan. So can I go after the medical provider? And the 11th Circuit, kind of following the same logic as that Connecticut case in Guerrero, said no, you can't. And so again, we're a little bit divided, but the one thing is clear, is that if you are an MAO, a provider, a downstream entity, and you have standing to bring a claim, you can always go after the primary payer if they have not paid you. So even if they funded a settlement and they've paid the enrollee or they've paid the provider, you can still go after them if they haven't paid you. Big important distinction from handling normal health insurance subrogation. Again, I'll mention that there's really one last hope of the insurance companies out there. They have this case pending at the Second Circuit Court of Appeals, which is headquartered in New York. It's really one of the, maybe the second biggest or the most prominent federal appellate courts out there. And so really the threshold question that was answered in Avandia, in Western Heritage, is going to be answered by the Second Circuit. And really, if the insurance companies lose this case, I think it's fair to say that really is the nail in the coffin for them. This is their last hope. It's a case that if somehow the Medicare Advantage plans lose, we would expect this case would probably go up to the Supreme Court. The case was argued to the appellate panel back in February. Our firm authored an amicus brief for one of the parties, and we're just awaiting a decision at this point. It's going to be a very big decision, and we're all going to be looking forward to it, and I'm sure that I will mention it on a future webinar when this decision finally comes out. Last but not least, I want to discuss one of the key features of the private cause of action that Medicare Advantage plans have to them that makes it very, very different from handling ordinary health insurance subrogation, ERISA subrogation, even workers' compensation subrogation, is that the Medicare private cause of action that we're talking about here has a double damages provision in it. So I back up just a bit, and we go back to the language of the private cause of action itself. In that parentheses up there, it talks that the action for damages shall be in an amount double the amount otherwise provided. That's the double damages provision, and courts have held quite uniformly that the private cause of action, because it uses the mandatory shall language, that is not discretionary. That means that if you file this action, you are going to be entitled to double damages. And the reason this is huge is because you've got to consider that when you're filing this action, you're likely filing it, especially in a liability case, where there's already been a settlement. So that insurer has already once funded maybe its policy limits to settle a case brought by a Medicare beneficiary. They've paid the beneficiary, and the beneficiary has run off with the money. Well, because we're a Medicare Advantage plan, we don't care. We're still going to go right after the insurer that failed to pay us. And now, because there's a double damages provision, that insurer is faced with paying not just once to the enrollee and not just once to the Medicare Advantage plan, but twice to the Medicare Advantage plan, meaning that they're potentially paying that amount 3 times. It's a really a big hammer that we can use to make sure that we are at the table at the time of settlement and that our interests are taken out of the settlement. So that is a provision that insurance companies don't like. And there is an organization out there called the MARC Coalition. It's basically a large group of insurance companies like American Family, Liberty Mutual, Progressive, Farmers, some of the biggest auto insurers in the country have aligned together to create this MARC Coalition to sponsor legislation that is aimed at getting rid of the double damages provision, getting rid of Medicare Advantage plans and their ability to recover, And so they go out there and they sponsor legislation that is aimed at undermining the Medicare Advantage plan's right to recover. In this case, they have now sponsored what is called the RAMP Act. It was introduced in June of this past year, and it would repeal the private cause of action in 1395 YB3A. It would repeal it altogether. Their aim here is to eliminate the cause of action, eliminate the potential for double damages. So if you're at any of those companies and you're doing this, you know, I understand. I understand why you're doing it. I'm not in favor of it. I think it would be it would allow us to then return basically to the way that it was done in the past, which was not reimbursing Medicare Advantage plans and basically skirting obligations that you have under the Medicare Act. So I'm hopeful that this legislation won't pass. It's one that we'll continue to follow up with. If it gets defeated or if it goes through, we'll make sure to update you in a future session. Well, that's kind of gives you a little brief history. There's certainly a lot more that we can update in maybe a more advanced session in the future. But without getting too far down in the weeds on some of the more nuanced issues, that's kind of where things stand from a big picture on our recovery rights for Medicare Advantage plans. But without further ado, I want to turn this over to Nancy, and she's going to kind of walk us through best practices if you're doing subrogation and recovery work for Medicare Advantage plans. Nancy?
Thanks, Ryan. Very good overview. Are you hearing an echo from me?
Just a little bit, but it's not too bad. I think you can roll with it.
All right. Okay, so let's start with things that you can do on your end when you are confronted with handling Medicare payer. The first thing you want to do is identify primary injury coverage and pay secondary in and in an automated process, but are you able to stakeholders via an incident or another mechanism as to who the potential parties or responsible parties might be? And do you have a mechanism to deny claims payments? If you have both of those, you're in a good position to move forward. But that's not always the case, and then you find yourself in a pay and chase mode. And assuming you have some investigative information, what you want to do is put all parties on notice of the conditional payments made and the expectation of reimbursement as soon as possible. Everyone does well as far as an outcome goes if you get in early and remind everyone often. And there are many CMS notice letters out there that you can utilize to send a strong notice message of the rights and the obligations of the parties. A lot of resources out there. Make sure that you're getting the most current, but go ahead and put everyone on notice that you're there and the payments are made, and share that information. So a good practice to mirror the CMS documentation will come via the initial notice letter, as we just discussed. Most importantly is the final notice letter, but you need to be careful and you need to make sure that the settlement is indeed final. Do you have proof that it's final before you send that letter? Because if you don't have proof that it's final and claims are still being paid after the fact, you could run into some trouble. So you want to make sure that you and your numbers are solid and that the settlement is indeed final. And then you want to send your payment demand with the proper waiver and appeal instructions. So again, mirroring CMS. And the optional appeal process for carriers is found in CFR 42, subpart 1 of 405. And it provides for a multi-level process, including a possible redetermination by the contractor issuing the recovery demand, a reconsideration by a qualified independent contractor, and an administrative law judge hearing. So many layers to the appeal process. But one of the primary grounds for disputing a demand for reimbursement is based on relatedness. So probably you have encountered in situations where a lien resolution group is handling a matter. They will send you, an initial letter saying, we have reviewed the relatedness of the claims and we dispute this, we dispute that. It's pretty commonplace in those situations, and that's where that letter is coming from the CMS processes, that the primary ground is relatedness. So they're going to be looking at that first, so you should be looking at that as well. The party should review both of the dates of service and the CPT codes and make sure that the relatedness is there. In addition to the challenge of relatedness, CMS also has the authority to waive a recovery in whole or in part if, and then there's some caveats, the probability of recovery or the amount involved does not warrant pursuit of the claim. And again, it mirrors a little bit in the ERISA context, in which do the administrative costs of pursuit outweigh just letting it go. So you do have that consideration. But again, if you want to mirror CMS, it's a rarely exercised by CMS, but they are present. So if you hear about them, it shouldn't be coming from left field for you. There's also a process that's based, a process to compromise based on hardship. The beneficiary may tell you that they have a future or current or future inability to pay. But again, that's also rare because if you're looking at a settlement situation, they don't have a complete present inability to pay.
Yeah, I mean, the appeal process is huge, and it's something that I just think it's important to emphasize, especially if you're doing work as a subrogation or recovery payment vendor, because if you're doing work for ERISA plans, there are appeal processes there, but it's more important and more significant on the Medicare side. And so you've got to make sure you have a process in place with the MAO, so that when you issue that payment demand and it comes back with an appeal, that there's a good mechanism in place to make sure that appeal process plays out and the beneficiary is receiving the correct appeal notifications and is able to appeal through the process. Because one of the things that is very different in Medicare and Medicare Advantage than in the ERISA space with appeals is that the enrollee has the ability to appeal your reimbursement determination all the way up through litigation. And it does that in a very different way than it does on the commercial side. Rather than potentially suing the ERISA plan after you're done with the appeals, the proper course here is to go through the administrative appeals process, not with the MAO, but it ultimately is an administrative appeal process that ends up with the individual suing the Secretary of CMS. And so it's a process that ends up with a secretary's determination, not with private Medicare Advantage groups determination. Sorry to jump over you, but I just wanted to point that out.
That's okay. I will now in a later slide go over all of that briefly, because I outlined exactly the weedy part of that. But thanks, Ryan, for giving us a heads up on what's coming in a little bit. That's perfectly fine. Something else to be thinking about too is that Medicare will typically demand reimbursement of any conditional payment regardless of liability. So if you are confronted with an objection that liability was not determined, which it rarely ever is, your next step, if you hear that, is to ask for a copy of the settlement agreement and find out exactly which parties will be responsible for the payment, and you'll get a little bit of pushback on that. And sort of like ERISA reimbursements, offer to execute a non-disclosure agreement so that you can become privy to the confidential settlement. You have the right to that information, so don't take anyone's word for it if you don't have to. And then again, circling back to, it's really important, don't provide the final demand figure until you have a really firm grasp on the settlement that's been reached. Something else to note, and we talked about a waiver. Medicare does allow for reduction in the amount of its conditional payment if the lien amount, if the amount of the settlement is less than the lien amount. and that is codified in 42 CFR 411.37D. So Medicare will generally reduce its recovery by procurement costs, with the total recovery not to exceed the amount of settlement. So it essentially takes the attorney's fees and costs off the top, then demands the entire remaining amount of the settlement, leaving no net recovery to the plaintiff. Under this reduction, only the plaintiff's attorney gets paid. There is a way for you to reduce under those circumstances under the statute. So just going to the basic statutory formula, and those are a lot of words right there, but there are a lot of words that you should have handy and that you should refer to often, and we'll get to this in a little bit in training. But let's go over it a little bit, because this is the guideline, the roadmap, if you will, for the recovery, and we'll get to the much easier way to make that calculation very shortly. But let's take a look at this. This is under Title 42, Subchapter B, Part 411, another statutory section that you should have handy that you can reference. And it is the amount of Medicare recovery when a primary payment is made as a result of a judgment or a settlement. So you have a judgment, you have a settlement. Part A, recovery against the party that received payment. The general rule is that Medicare reduces its recovery to take into account the cost of procuring the judgment or settlement as provided in this section if, and there are two ifs, if the procurement costs are incurred because the claim is disputed, it gets litigated, and, not or, and those costs are borne by the party against which CMS seeks to recover. So moving on from that, there's a special rule. If CMS must file suit because the party that received payment opposes CMS's recovery, the recovery amount is as set forth in paragraph E of this section. So again, jumping from here to here, it's a cobbling. Going down to E, if CMS incurs procurement costs because of opposition to its recovery, if it must bring suit against that party, the recovery amount is the lower of the following. So the recovery amount is the lower of the Medicare payment or the total judgment or settle amount minus the total party's total procurement costs. So, okay, understand the special rule. Now the recovery against the primary payer. If CMS seeks recovery from the primary payer in accordance with 411.24I, the recovery amount will be no greater than the amount determined under paragraph C, D, or E of this section. Moving on to C. So if the Medicare payments are less than the judgment or settlement amount, and this is important, the recovery is computed as follows. First, you determine the ratio of the procurement cost to the total judgment or settlement payment, and we'll get to that in the next slide. Then you apply that ratio to the Medicare payment. The product is the Medicare share of procurement costs. Then what you do is you subtract that Medicare share of procurement costs from the Medicare payments, and the remainder is the Medicare recovery amount. So that's your final demand amount. Now Part D goes into if the Medicare payments are equal to or exceed the judgment or settlement amount. So if the Medicare payments equal or exceed the judgment or settlement amount, the recovery amount is the total judgment or settlement payment minus the total procurement costs. So those are a lot of words, but that is the roadmap that you must follow to come up with the calculation. So let's move on to slide 17. Next slide. Ryan, did you get, there we go. This is a Medicare reduction formula that I set up in Excel. So I had to do it one time. It took me a while to get there, but it has been immensely helpful in calculating Medicare recoveries. So you must find out what the gross settlement or the judgment amount is. You need to find out the attorney's fees, and you need to know the litigation or other costs. And as shown at the top, you just plug in the gross settlement amount, and I just made these numbers easy so that we could follow along on the slide. The Medicare payment amount, the attorney's fees were $5,000, and the litigation and other costs were $500. So below that, then you come up with your total procurement costs. Then you ask the question, per the statute that we just read, is the Medicare payment less than the settlement or judgment? And in this case, yes, it is. So you follow Formula 1. So I created the formula that determined the cost ratio, which is not that difficult. And then it calculates the lien reduction amount under that calculation. And then it tells you what your final demand amount is. So pretty easy enough just to plug and play that formula. And then at the bottom, it shows how you can check your numbers, just like in math class. The Medicare final lien amount, the procurement cost, and then the residual to the injured. So you can see what that amount is, and then your total recovery is there as a check. So that is a situation where the lien amount is less than the settlement. And Ryan, the next slide. Is much smaller, so I'm gonna have to make mine a little bit bigger too. It was a last minute addition because I figured we'd want to see what it looked like. Okay, so for this example, if you want to follow along, the gross settlement amount was $40,000. The Medicare payment was $45,000. The attorney's fees were $5,000 and the litigation costs were $500. So we come up with the total procurement cost of $5,500. And under the formula number 2, the final lien demand is under this calculation, $34,500, which sounds like, well, that's not really bad. But then when you run the check, you have the Medicare final lien amount is the $34,500. The procurement costs, where the attorney gets paid and the costs are paid, $5,500. Residual to the injured party, not available. They don't get anything. That's the situation that we talked about before. This is where you can exercise either waiver or work it out with that party, either a waiver or another reduction scenario that you can substantiate to CMS when you're doing your reporting on that end. So that was kind of a quick explanation of how to come up with the statutory formula, but it looks a little bit more complicated than it actually is. And this next slide just goes through the written words of, and I have this at the bottom of my Excel spreadsheet, so that in my mind, it's clear what it is. If I get a call from a beneficiary or their counsel, we're able to talk through exactly where the calculation came from. Okay. Best practices. What can you do on a day-to-day basis if you have one of these files? Well, you can facilitate an appeal process. And Ryan talked a little bit about that, but my caution for you is watch what you wish for if you start to go down the appeal road. There are appellate rights when reduction and waiver requests fail. You may not have an opportunity to avoid that, but just understand that the first level of appeal is called a redetermination, and it may be submitted in writing within, and again, these are timelines. You'll want to make sure that you are following the timelines as well. This is a little, also slightly ERISA related. The first level appeal has to happen in writing within 120 days of the issuance of the final demand. So the date between your final demand and when an appeal may come your way is 120 days. And it's considered an initial determination. So once that is issued, the beneficiaries, providers, suppliers, they may appeal the recovery amount as codified in CFR 405 subpart 1. And there are 5 levels of appeal. There's redetermination, reconsideration, ALJ hearing, Medicare Appeals Council review, and then finally U.S. District Court review. And a party may not obtain review by U.S. District Court unless and until they have exhausted the 4 initial administrative appeal stages. So there's a lot there. This is a process, also like ERISA, called exhaustion of administrative remedies. And there's no threshold amount in controversy for a redetermination to be reviewed. And any evidence to support the request for redetermination is to be reviewed by you, the contractor. So if the redetermination is not favorable, the parties have another 180 days from the date of the redetermination to request a reconsideration. And then under the reconsideration, it must be reviewed by a qualified independent contractor. And there's no minimum amount in controversy to have a reconsideration reviewed. So prior evidence submitted to the contractor is to be reviewed by the QIC along with any new evidence the parties may include include in the request for reconsideration. And we all know attorneys can always come up with new evidence as any process evolves. So if the reconsideration is not favorable, the parties have 60 days, so now we're getting a little bit shorter, after the receipt of the reconsideration to request a hearing in front of an administrative law judge if it meets the amount in controversy requirement. So the current amount in controversy requirement to request an ALJ hearing is $160. The ALJ will review the evidence that's contained in the record and the previous 2 appeals, and then they will consider additional evidence if there is good reason that the evidence was previously left out of the previous appeals. So we're narrowing the scope a little bit. We're starting to narrow things down, but not much. If the decision by the ALJ is unfavorable, then the parties have 60 days from that date to request a Medicare Appeals Counsel review. Now, there's no current amount in controversy needed for a counsel review, but the counsel has to limit its review to the evidence contained in the record before the ALJ, unless the ALJ's decision included a new issue that the parties did not address at an earlier stage. So you can just see the tentacles of where this appeal process could possibly go. If that decision is unfavorable, then the parties have 60 days from the date of that decision to file in a U.S. District Court. If the file meets the amount in controversy for the appeal, and the current amount in controversy as of 2019 is $1,630. So we're talking very low dollars here, but very high administrative costs. So you have to weigh those, balance them against one another. So this is the final appeal at the U.S. District Court level, and the decision by the Federal District Court described above is binding on all parties. So again, watch what you wish for if you want to steer in the direction of an appeal process. The next issue that you can confront is a waiver and a reduction for low value settlements and toxic exposure torts. It's codified under 42 U.S.C. 1395 YB9A. It dictates that this reduction and possible waiver are allowed. So practically speaking, again, from an administrative standpoint, how much is the Medicare lien? How much is the settlement? Exercise some discretionary authority there. Again, with an eye toward administrative costs of the recovery. So what about a recovery reduction for attorney's fees? There is an interesting case that I think illustrates this quite well. In the past, and a little bit of the Wild West of Medicare recoveries, the Angino law firm represented a Medicare beneficiary in a state medical malpractice case. The case was against Bloomfield Pharmacy, Inc. and Biomed Applications of Pennsylvania. So Medicare conditionally paid approximately $84,000 for the client's medical care. The Angino law firm settled the state medical malpractice claim and received payment on behalf of the pharmacies. And under the Medicare Secondary Payer Statute, they should have been required to repay Medicare $53,295. They refused. They didn't pay it. And the United States filed suit to recover the money owed to the government. Now, this case, if you follow the timelines, it's 2011, the lien was created. The United States sued to recover that money in 2017. So these cases can take a while, long time. After extensive litigation in the district court, the parties agreed to amicably resolve the matter. And under the terms of the settlement agreement, the law firm paid the United States over $20,000, and they paid Biomedical Applications of Pennsylvania. And Biomed Applications paid the government $33,000, which they set aside in escrow, probably a smart move, from the state medical malpractice action. The settlement agreement itself was not an admission of liability on any part, but it did result in the Medicare program being reimbursed in full the funds it expended for the client's treatment. So this litigation does happen. Moving on to slide 20. Selecting cases to litigate. Pick your battles. If every T is not crossed and I dotted, and in these situations it can be difficult to do, you will be called out on it. Just be prepared for it to come back your way if you didn't have a very solid process to begin with. So some things that you want to think of as far as best practices go, and we talked about it a little bit earlier, was there proper notice prior to the settlement? What kind of notices were sent out? Was there monitoring and updating of interested parties? Personal injury attorneys especially get very irritated when they received a notice of a $300 claim, and then, you know, a year and a half later, whatever it might be, the claims are up to, you know, whatever it might be, 75,000. They're in a little bit of shock. Make sure you're keeping all of the interested parties adequately aware of the payments that are being made. Then you want to make sure that your demand was properly calculated, and that your demand included the required waiver and appeal information. And then again, going back to administrative costs, you know, has every effort been made to negotiate a reasonable resolution? But even if you didn't do all of that perfectly, one of the things that you want to take into consideration is there evidence that a payer or attorney made concerted efforts to avoid reimbursement obligations. It does happen. Document your file as you get any obstacles, pushback, questions, and make it a part of your monitoring process, and ask for information from them. You know, ask for you know, any kind of you know, demands that are made, any mediations that might come up. You yourself can try to stay on top of the docket information, but definitely request and demand responses to your requests for information. So as a final note, good processes for you in pursuing these claims is spend the time, understand the basis for recovery, understand, again, the CMS manual, try to gather all of your resources, create and implement a solid handling procedure, create and implement a solid resolution procedure, and then with all of the people that you might, you know, be involved with handling these kinds of cases, make sure that you're training them and reviewing these. There's a lot here. An annual review wouldn't be out of the question in order to make sure that you are properly seeking recovery on these claims. And I think that about does it, unless Ryan, you have anything else to add? I know we're a little bit over time here.
No, thank you, Nancy. That was super awesome with best practices. I think that really helped. And for everyone out there, we'll send along a copy of the PowerPoint, so you've got it. You've got the calculations. That was really helpful for Nancy for putting that together. Next month, though, I just want to give a brief announcement. We're going to try to do something a little different. Catherine will be back to join us next month on the 25th at same time. But we're going to do like a roundtable, and really what we're asking you to do is submit questions that you want answered, and we will answer them. Anything you want, really. You know, from ERISA to FEBA, any questions that you have that you think we haven't covered, we will cover. We will drill down if they're really specific. If you want a roundtable, the facts of a potential case, email us. We will go over that and kind of give you our thoughts and the way we analyze it. We'll try to shoot around an email after this, basically announcing it and then providing you with an easy way to shoot us some questions. We'd like to have the questions in by the middle of the month, so we've got time to fully prepare answers to them so they're ready. But we'll accept questions up to the day before if you have to, and we'll try to see if we can prioritize them. But yeah, so thanks for joining us again, and we look forward to your questions, and we look forward to talking to you next month. Nancy, anything else?
I think that'll do it. It should be fun next month, and whenever you and I get around to, you know, entertaining hypotheticals, how you handle it versus how I handle it always makes for some amusing moments.
It sure does. All right, well, thanks everyone. We'll talk to you next month.